Where is the line between public record and an invasion of privacy? In my last video, I talked about how the government of Nova Scotia seriously screwed up and allowed a number of decisions of the province's Workers' Compensation Appeals Tribunal containing some very sensitive personal information to be posted online and made publicly available. They were meant to be redacted to protect the identity of the parties, but unfortunately were published without the redactions. In our democracy, our courts are supposed to be open. What is in the court file and the resulting decisions should be a matter of public record. At the same time, our courts and our tribunals are often dealing with some of the most intimate details of private lives, particularly in criminal, family, and child protection matters. Is there a balance to be struck between making sure that justice is done and the corpus of precedent-setting jurisprudence is available to those who need it, on one hand, and protecting the legitimate privacy interests of those involved in the justice system? Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and hopefully informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a very high-level overview of a pretty nuanced subject. Any opinions expressed in this are mine and mine alone, and should not be attributed to my firm or any of its clients. I touched on this topic of privacy in the courts in a video on privacy laws in the media, but I'd like to take a deeper dive on the topic of court and tribunal decisions. This is largely based on past presentations I've given to judges and tribunal members. In civil litigation, each party has a very broad right of discovery of records, and just about anything that is relevant can be put on the public record. The same idea generally applies to family and criminal law matters. And often it is the case that personal information ends up on the public record. But what about personal information that ends up in written decisions? In a bunch of ways, this is a relatively new issue for consideration. Before the internet, court decisions were contained in published law reports that could only be found in law libraries and at law firms. Anyone who was really interested could go to the courthouse as well. The internet significantly changed the possibility of these things being read by non-lawyers and possibly being surfaced when somebody is using a search engine to find someone. Canada's largest online repository of case law is CanLII, which includes just about every recent published court decision and those of many, many specialized tribunals. They have a practice to protect the privacy of individuals named in court decisions by preventing their site from being fully indexed and searchable by most search engines. It's not perfect, but it generally keeps most of the decisions behind a bit of a technical gate. As I understand it, most government websites that also host decisions follow this same practice. And as an additional protection, many tribunals and some courts will only publish redacted or edited versions of their decisions to protect or to prevent the identification of the people involved. There was a case a number of years ago in which a Romanian entrepreneur ignored the directions of sites like CanLII and scraped their decisions and posted them on their own website, globe24h.com. It was ostensibly to provide access to these materials, but it really was an extortion racket. He took steps to make sure that all of the decisions posted on his website were indexed by search engines. Then people would search for their own names, those decisions would appear in search results, and people were concerned that their sensitive personal information was out there in public. The operator of the website would charge a fee to have those individual decisions removed. Following an investigation by the Privacy Commissioner of Canada and a hearing in the federal court, the website is no more. But it really does highlight possible concerns about sensitive personal information appearing on the public record. Court decisions are simply more findable than ever before. There have been cases where the courts have said that fears about a loss of privacy can be a barrier to access to justice. This was recognized in the case of AB and Bragg Communications that my firm took to the Supreme Court of Canada to protect the privacy and anonymity of a 15-year-old girl who was a victim of sexualized cyberbullying. Courts and judges are not subject to privacy laws, but there has been a discussion within the judiciary about privacy in written court and tribunal decisions. I've spoken at a number of continuing education programs for judges and to tribunal members about privacy in these decisions. There really are two competing tensions. The first is that most courts and tribunals have an obligation to give reasons for their decisions. First and foremost, so that the parties know how a decision was arrived at. And secondly, to actually have a record that could be intelligible to a court of appeal or another reviewing tribunal. As Justice Leroux Dubé wrote in a decision called Baker in Canada in 1999, quote, "In my opinion, it is now appropriate to recognize that in certain circumstances, the duty of procedural fairness will require the provision of a written explanation for a decision. The strong arguments demonstrating the advantages of written reasons suggest that, in cases such as where the decision has important significance for the individual, when there is a statutory right of appeal, or other circumstances, some form of reasons should be required. It would be unfair for a person subject to a decision such as this one, which is so critical to their future, not to be told why the result was reached." Unquote. This often necessitates discussing and analyzing personal information about the parties or other people who are involved, and that information is sometimes very sensitive. The other competing tension is to protect the legitimate privacy interests of people who are involved in the litigation, either directly as a party or otherwise just somehow involved. The Canadian Judicial Council has taken note of the issue and released a paper in 2005 on the use of personal information in judgments and a recommended protocol. It principally focused on publication bans and whether judges or legal publishers should take the first responsibility for ensuring that published decisions do not violate any applicable publication bans. But it does take note of privacy issues more generally. The CJC paper focused on 3 types or levels of protection. The first is personal data identifiers, such as birth date, social insurance numbers, credit card, and account numbers. The obvious mischief sought to be avoided is identity theft and fraud. The second relates to publication bans, which often prohibit identifying witnesses or complainants in certain kinds of cases. The third is much more broad, looking at protecting the identification of persons where it could harm them or subvert the course of justice. Overall, it mostly focuses on whether to specifically identify people. Privacy goes a bit beyond that, and I'd suggest it may be time for an update of this guidance document to take into account the broader recognition of privacy harms since 2005. The paper does note at paragraph 32 that, quote, "protection of the innocent from unnecessary harm is a valid and important privacy consideration." One of the first steps is understanding what is a possible privacy harm. I often turn first to section 10.1 of PIPEDA, which is used to determine if a privacy breach creates a real risk of significant harm. It says, for the purpose of this section, significant harm includes bodily harm, humiliation, damage to reputation or relationships, loss of employment, business, or professional opportunities, financial loss, identity theft, negative effects on the credit record, and damage to or loss of property. Most people first think of identity theft or identity fraud, as the Canadian Judicial Council did. Sometimes court decisions can include the basic information that can be used for such mischief. Name, address, and date of birth can be easily used for fraud. I can easily imagine a family court decision including the full names of the parties, their dates of birth, and the address of the matrimonial home. It may even say that there's a mortgage with a particular bank. Someone with ill intent could use that for fraudulent purposes. I've seen family court decisions with the full names and dates of birth of all the children in the family. I generally advise that if the full date of birth is not necessary, it should be omitted. With respect to non-parties, initials or other generic terms could be used. For example, the plaintiff's 10-year-old daughter, CD, using initials, or the defendant's bookkeeper, without the name. There are risks to reputation, which are sometimes harder to deal with. In a defamation case, the plaintiff's reputation is front and center in the litigation and hard to avoid. But in other cases, I think a decision writer should make an effort to shield someone from undeserved harm to their reputation. A risk of physical or bodily harm could be an issue. Family law cases are again easy examples. A custody decision may say what school the kids attend, where they undertake recreational activities, or places that are frequented by the parties. Immigration and refugee decisions could contain information that could get somebody killed. If those details are not relevant to a decision, they should be omitted or replaced with more generic terms. So what? I don't know how many judges are watching my YouTube channel, but lawyers and litigants do have a role to play in this. It is, after all, the litigants who bring all the evidence and all the arguments before the courts. They have a gatekeeper function. I think the lawyers involved in any case where personal information is at issue should consult with each other and see whether there are any steps that they could take to limit what sensitive personal information goes into a court file, which is, of course, publicly accessible. There generally is nothing to prevent the parties to a case from agreeing to redact certain information in their evidence and exhibits. For example, if tax returns are relevant to the case, they can agree that certain information, such as address, social insurance numbers, and birth dates, could be redacted. If those details are not necessary or relevant to the judge to make the decision, they should be kept out of the court file, but make sure to tell the judge why the details have been redacted. And if the judge doesn't have a specific detail, it's not likely to make it into a decision. Judges will often pick up on terminology used by the litigants. If the lawyers describe the kids as the eldest and the youngest children, rather than Mary and Jane, the judge is more likely to do so in their decision. And finally, there's nothing to stop a litigant from asking a court to omit certain personal information or details from a final decision. The judge absolutely has no obligation to do so, but judges are humans and are increasingly sensitive to these issues. After a decision has been published, it's likely too late to do anything about it. I hope this has been interesting and useful. I try to put out a new video each week or so, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or have any suggestions for any other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.